Item 801.
Tag with civil appeal number
My lord, the issue is entirely
1016
different.
of
My lord, I am
2025.
counsel for the petition, my lord. The issue is entirely different.
Why?
My lord will see in the order of issuing notice, my lord. It mentioned at para 3 that an interesting question arises that there are two contradictory awards existing at that time, my lord.
The
When notice
question is not whether a writ petition would lie against an award.
In the impugned order.
in the
Does that question arise?
Yes.
If that question arises, then it
That
has
is
to
the
be
primary
Lord,
question. Secondly
Lord,
is
give us,
tag with civil appeal number
my lord, give us opportunity to
1016.
put forth
You
our.
can argue before the constitution bench when the
Lord,
matter
it's
comes up.
entirely different, my lord.
We are very well write this. We are informed that the issue that arises in this specialty petition is primarily as to the maintainability of a writ petition under Article 226 of the Constitution against an award passed by the Micro and Small Enterprises Facilitation Council, as that very issue has been referred to a larger bench by a three-judge bench in civil appeal number 1016 of 2025, titled Messrs. Tamil Nadu Cements Corporation Limited versus Micro and Small Enterprises Facilitation Council and another FAMA. Registry is directed to tag this specialty petition with the said appeal.
Item number 1.
Please.
37.
Application.
You have
Application is
completed, two
7
of them have completed 7 years.
Yes, Your Lord.
And there are eyewitnesses to the,
Eyewitnesses not role assigned by
only
me.
one eyewitness is related, the other two are independent eyewitnesses.
They are nephews to the of the deceased. They all eyewitnesses believed by both the courts.
Your Lordship, petitioner number
Not
1
case
is.
for grant of bail. Normally, at least 10 years should be over
Your
before we
Lordship,
say that
kindly
all right, we're not
one minute, Your Lordship.
You can list the appeal for hearing.
Kindly, Your Lordship, give me 1 minute, thereafter I will leave it. Your Lordship, on 30th of January 2020, Your Lordship directed that the bail application is not be heard on merit at this stage. Thereafter, Your Lordship, again, 16th of February 2024, I have not pressed my bail application. Your Lordship, appealant number
We will
1.
give you a date so that the main appeal can be.
My Lord, appealant number
We are
1
not-
is 71-year-old. And you
He spent 7 years in prison, and in the presence of eyewitnesses, that man is murdered.
Your Lordship, role, according to prosecution, role assigned by me is.
While he is answering a call of nature, you kill him.
Your Lordship, I am not killing them. Role assigned by me.
That is the conviction.
Your
That is the
Lordship,
finding of two courts.
Conviction.
That of course is subject to appeal, but two courts have held against.
Then Your Lordship, my application will get a pending letter of my Lord.
We find no grounds made out to grant bail to the appellants at this stage, considering the fact that two courts have held against them. List the appeal, the IA is accordingly dismissed, list the criminal appeal for hearing on 12th November.
I tap up board, Your Lordship. Kindly, Your Lordship, petitioner is
It's a Wednesday.
Your Lordship, petitioner is
It's a
71.
Wednesday, so
It's
you have
my lord.
15 matters, be ready on that day.
But Your Lordship.
Nothing further, nothing further. Go counter,
Service is complete, but no one
someone is appearing?
has filed appearance so far, my lord, in this case.
This is
He's
the
in
state
jail
of Madhya Pradesh again.
Since November 23.
Have you served notice on the designated standing council? Anyone for the state of Madhya Pradesh, any standing council?
My lords, I'll serve the standing council. My lords, may I have it on next Friday.
Despite service of notice, the state of Madhya Pradesh has not chosen to enter appearance. The council for the petition is permitted to effect service of notice upon the standing of the designated council for the state of Madhya Pradesh. List on next Friday.
Thank you,
Item 3,
I appear for the mediated complainant.
for the complaint.
And he's in Russia.
So he's gone off to Russia.
He was in Russia, he's never come back. Not,
He's a Russian citizen.
he's chosen not better clients.
I am immediately ready to come back. I came back on the 12th of September.
and then left again.
No, let me just explain for a moment. What happened was,
12th of September is today.
no, last year.
Last year.
Just before this whole thing came about. We have been working together for the last 12 years. In January last
Yeah,
year,
if you're not even in the country, what interim protection?
I want to come back, Lord. I'm very keen to come back. I had to rush.
Any
back.
lookout circular has been issued?
No, Lord, no.
Then why do you can come back?
Lord,
Your
my
passport is not going to be scanned, no regular notice.
May I just explain? I had filed my complaint on 15th of September was of kidnapping. I had a 99% share in the company. They took it over, would not allow me to go there and kidnap me for it. My FIR, Lord, was prior to that. Immediately this FIR is lodged saying that
How much money went into your mother's account?
2 crores, and that is on 3rd of August. And that is, if your Lordship may kindly see page, Lord, for a moment.
If there's no lookout circular, what is the difficulty in
But
coming back?
I'll explain, bro. I went to the NCLAT. I got an interim order that yes, you can go and inspect that factory, your factory, where you were not allowed to come
You're
in.
not answering the question, Mr. Tiwari. What is the difficulty in coming back?
I'll be arrested, bro.
Why will you be arrested if there's no lookout circular, no red?
Lord, my anticipatory bail has been rejected by the High Court. They are very
There's
powerful.
no lookout circular according to you, no red corner
Lordship,
notice.
come back.
So where is the question of any immigration authority immediately flagging your arrival in India and then arresting you?
Because I have to go and inspect that factory, and that is why they don't
Come
want
back.
to come back.
You first come back and then we'll consider.
Lord, I'll come back in 10 days.
There's a second,
Where just a moment.
P9 at 90, he filed second time, then withdrew that.
Yes, because I'm
So
not.
this is a.
First, let him come back. Then we'll have.
Lord, the Lordship may kindly protect me. I'll come back whenever you.
Come back first. We'll take it up. When are you planning to come back?
Whenever your Lordship says, Lord, kindly
You
protect
come back
me.
and we'll give you a short date.
I'll be arrested at the airport.
They are very powerful, Lord. My FIR has been quashed, and the same honorable judge has dismissed my.
They can't keep an eye on the airport to see every flight that's coming from Russia and how many people are getting down, who's getting down, whether you're there, whether you're disguised or.
I've lots of charter flights to go out these days. Lots of charters go straight to.
Lord, kindly protect me. I'll come back. And I'm not.
Come back.
Lord,
Once you say that there's no red corner notice, where is the need for?
Lord, I'll explain, Lord. Even before the learned High Court, I'd said that this 2 crores is lying there. I'm ready to deposit it, give it back. It is given on 3rd of August. They are saying March. And kindly see that document, Lord, for a moment. How it is given.
But Mr.
Kindly see
Tiwari,
for me.
where is the difficulty in coming back? You're just
No, I'm-
apprehending that something will happen.
Yes, Lord,
When you say that there's no lookout circular or a red
But I
corner
was
notice, where is the
kidnapped-
question of
I was
immigration
kidnapped,
authorities
Lord.
doing anything?
I was kidnapped by
Very well,
99.
that's your cross FIR.
Yes, Lord.
Well, obviously you were let off. Otherwise, how would you be in Russia then? They took you to Russia and let you off.
No, Lord. I had to run because I have a special. Lord, kindly see.
You have a special charter.
No, I have a special channel. But kindly turn to page 20.
Let him come
For a
back.
moment, your Lord.
Come back.
I will.
You come back and you come back and then you go to our
Yes,
charter.
terrible, Lord. You can just, your Lordship.
Come back first, then you'll have interim protection. This running away from the country is not done. He's a Russian citizen also.
That's right.
Yes.
That's
I
right.
deposit my Russian citizen. 1 year he's been away. Lord, he's
Then-
not come.
Lord, I'll
give
come
you a-
back, deposit my passport, but your Lordship may protect me.
First you come back, then we'll protect you. 2 weeks?
As your Lordship.
This is on
Just give a fixed date.
26 September.
Great. Obliged.
The post.
The complainant has filed, Mr. Luthra. There's an implead, is it? Implead application is filed.
There's a caveat.
No, but the complainant is not made a party here.
No. He was not a party in the High Court.
ALOK, we had filed a caveat.
You filed a caveat, but you're not made a party.
No, not a party.
The complainant,
They were not
give the
part.
details of the name and address, is, who was heard by the High Court, is not a party to this special petition. He is suo motu impleaded as respondent number 2. Which notice need not be served,
Maybe your Lordship may issue notice, will not protect me, I'll come back.
as he is already on caveat, represented by learned counsel on caveat.
Your Lordship may consider issuing notice and not
Notice
for 26th of January, for 26th.
returnable on that date. Counter affidavits, if any, may be filed well before the said date, to enable the learned counsel for the petitioner to file his rejoinder as said.
Item
Four.
number 4.
This will tag with SLP criminal number 12510 and same interim protection.
Lord, please take that first.
Your Lordship had included me as respondent number 2, my Lord. Just not direct include me.
Here also you need to be stated.
Yes,
And that we are included. No?
yes,
That is same one.
Same one.
Lord, may I just make one more request? Your Lordship had kept the matter on 17th, not on a non-miscellaneous day. Lord, after this SLP, my Lord, notice, etc., may take some time. Lordship, we get some non-miscellaneous day.
Let it come up on that day. If you want time, we'll give you some.
17th, my Lord, is coming up.
Can't change the date in the earlier manner.
17th.
Let it come up after that.
Yes.
Wait.
This before a bench. One of us. Expedition.
My appearance will not physically because I am.
We are adjourning the matter for that also.
Yes,
you
only
collect fees.
instructions I am giving for respondent. I will give my.
For an we adjourn the matter also, you will collect a fee, is it? No, we don't know. Do you collect a fee even if once you step into the door, you can? You're
Yes,
entitled to
I-
a fee even if the matter cannot be heard by this bench?
No, I will file wakalatnama. Wakalatnama I
Very,
have.
but why do you want your appearance to be
informed
recorded?
before.
For what reason do you want your appearance to be recorded? This bench cannot hear this matter.
Yes, yes.
That is the
I know.
reason why it's going
I
elsewhere.
know.
Why do you want your appearance to be recorded?
Will you, Lordship, please.
Item number 6.
May please, Your Lordship, my Lord, the section 11 has been allowed and on 3 counts, my objections have been rejected, my Lord. 2 counts I'm not going into, my Lord, of pre-deposit and an arbitrator according to the panel.
Arbitrator is appointed.
Well,
That's a question about interfering.
My only.
Whatever issues you wish to raise it before the arbitrator.
Please, my Lord, they kindly.
Delay condoned, however, we find no good ground in these interfere with the judgment passed by the High Court, especially petitions according to this.
Please.
Item number 7.
Yeah, please.
Look, filing itself is on 7th August. It's not a case of defective filing, which is the issue in the other matters which the registry seems to think are connected matters. But it's not connected. You filed it well beyond the period prescribed in section 34.
Yeah, by
30 months, 3 months plus 30 days expired in.
vacation period.
So you take till August. That's the question. Delay condoned, however, we find no good ground and reason to interfere with the judgment passed by the High Court. Especially petitioners according to dismissal.
Item number 8.
The matter is adjourned.
Lords, may I have it on next Friday, please?
Adjournment is sought on the ground that the learned counsel for the appellant is suffering from conjunctivitis. Best. Once you take an adjournment, leave the date to us. The matter is accordingly adjourned based on 3rd, 27th October.
Item number 9.
Please, ma'am. There was a contingency, my lord. I completed the building in time. I took the lift like
What
this.
happened on 9th July 2025?
But so far, I have not.
Execution petition was supposed to.
Not,
have come
I
up on
have
that.
complied with the traffic.
What happened before the RERA on 9th July 25?
Lord, I have complied the order.
Why did you show us the order?
I'll file the order, my lord. But I could not hand over the possession.
You've
my
not
lord.
filed a copy of the same deed dated 25th June 22.
Lord, that I will file.
You've not filed that.
But that is
This
not
selective
disputed.
filing, we've
That
already
is not
said it time
disputed.
and again. You need to file all the.
I
relevant
apologize,
papers
but
before
that
this
is
court.
disputed. That is why.
You can't fall back on the earlier agreement
Look,
without
I'll
showing us what the sale deed
kindly
says.
give me liberty. I'll file.
Sorry, we are not inclined to do that.
Lord,
Delay
Lord,
condoned.
kindly see.
However, we
There is
find
no
good
fault of. There is no.
reason to
Lord,
interfere
that
with the.
sale deed is not disputed. My lord, may kindly have the
You
order.
kept the man's money, how many lakhs?
44
44 lakhs. Where is the question of you're saying I won't pay interest on that?
My lord,
You
kindly
don't
see.
give him
There's
possession.
no delay on my part. My lord.
There, whatever
Delay
be
is not part of
whatever
the
be the delay, you kept his money. You don't get to keep some one
Section
reason or the
212
other, you don't give him possession.
Section 212 part 2 bars me to hand over the
Delay
possession.
condoned, however, we find no good ground and reason to interfere with the impugned judgment passed by the High Court, especially petitions according to dismiss. 49 also.
49.
Item number 10.
Great, sir. My lord,
Remedy is left open to you. Why don't you go before the state consumer dispute redress
Lords, may
commission?
then consider my limited submission that if an appropriate application is filed before the state commission.
We are
that will
not
be
here to
decided-
give you those nudges and pushes.
My
You
lord,
apply to the state consumer.
that will be
Dispute
decided time,
redress.
just that direction.
Sorry, we are not here for that purpose, sorry. Delay condoned, we find no good ground and reason to interfere with the improved judgment passed by the High Court, especially petitions accordingly dismissed. However, the remedy suggested by the High Court is left over.
Item number 11.
11,
Permission to pass on.
sorry,
Pass on.
pass over, not pass over, pass over. Yes.
Well, the limited question is that, Malak, without giving any reasons.
Discretionary orders of the trial
Discretionary-
court, we are not.
I am not saying, Malak.
There's no arbitrariness.
There has to be.
How many
reasons.
days delay is there?
100 days,
Yeah, well-
100 days. But they know.
But
Malak,
we
there are
find no
not
good
any
ground and
grounds,
reason to
Malak.
interfere with the interim judgment passed by the High Court, especially petitions accordingly dismissed.
Please.
13. Another request.
We'll issue notice in this. You don't want notice?
No, madam, I'm requesting for a status.
Status calls. Delay condoned. Sure. I can do it. No, issue notice returnable on 3rd November. That service shall be affected by all modes including justice. Status quo with regard to the possession and nature of the property in question shall be maintained. Obtaining as on today shall be maintained till the next day.
Item number 14.
Because I'm conscious that there is one appeal which has already been dismissed. However, my lord, I wish to point out, let me
Change
respond.
of-
My lord, allow.
Change of AOR, change of senior counsel.
Allow, my lord, it's covered
Same
by.
ground. How did you lose the original order,
Papers.
the certified copy?
Illegible.
From Hyderabad to Chennai, did you go by train, did you go by walk?
My lord, let me just.
July
address your
24 is the,
lordship's-
July
That-
24 is the e-filing
Right,
and lost till February 25.
that is right.
So
Because,
how did it surface? You found it by the roadside,
my lord,
Hyderabad,
that
Chennai
has
highway?
happened in the advocate's
Ms.
office.
Madhvi,
No, my lord, may I just address your lordships for a
they
moment?
already told you, change of AOR, change of senior counsel makes no difference to
No,
us.
change of, my lord, that
doesn't
doesn't
make
make
a
any difference. I'm
That's-
only saying this, my lord.
Unfortunately, here the impression seems to be that the change of counsel makes a lot of difference.
I hope not.
But at
my
least,
lord. I
at least
hope not.
before us.
No, I hope not. That should not be the case. I'm only saying this, my lord. There are two more appeals and this is going to go to the root of the matter, to
No
my
question.
MSME status. That is the only reason we are, my
The
lord, I can only leave it at that.
NCLAT is entitled to examine whether your reasons for delay in refiling also are genuine, acceptable. These reasons, on the face of it, we
If
can
it
find
happens,
no
I
fault
will-
with the understanding of the NCLAT that these reasons are make-believe.
Lord, if it
Nothing-
goes to the root of the litigants,
We
my
find
lord's rights.
no grounds made out to
Right.
interfere with the judgment passed by the NCLAT Chennai. The act is accordingly dismissed.
Item number 15.
Adjournment is sought by the learned counsel for the petitioner by way of a letter on the ground that he's suffering from viral fever. This on 13th October.
16.
Wait, please, Your Lordship. Millard, in this matter, Millard, I had served the NHAI for a good 15 years. Millard's 2,000 crore.
As their very nature aren't personal. It is not a public interest litigation for all and some
Millard,
to say I have something to say.
just one moment, Millard. Your Lordship may hear me for a minute. Millard, the total amount of the debt was 2,000 crore.
Whatever it
No,
is,
Millard,
there's no question of opening this
let's make a fair suggestion. May I just make a fair suggestion?
There's no question of
May I
even
just make a
opening
fair-
this door.
May I just make
Your
a fair?
cases
Millard, then we
limited.
have to read a judgment from this honorable
Whatever
court.
it is,
in
we
May.
are not opening this.
Millard, this honorable court passed.
Arbitration proceedings, every Tom, Dick and
Kindly
Harry
see
who
Justice
wants to come and
Suryakant's-
say, I have
Millard,
something to
kindly
say.
see 2 paragraphs of Justice Suryakant's judgment of May.
Did he say that a third party to an arbitration proceedings can file an application?
It may not be an arbitration proceeding, but it is
This
also a
is
general
arbitration proceeding.
proceeding. Millard,
Sorry.
2,000 crores of the exchequer's money This is a large volume. Milord, this is a fraud, highest level fraud that has been committed, Milord.
Without
Only
interference.
please, they can hear me.
By the High Court, the specially petition.
Milord, my only request is to hear.
Dismiss,
Is
next
be
matter,
heard, Milord.
next matter.
2,000 crores of the exchequer money just going down
You
the
go to
drain.
the NHA and give them the information. Sorry, you have no locus at all to appear. Sorry, next matter.
I'm appearing
Yes.
for this 65-year-old lady who could not
Sleep over the matter.
Only one
nothing.
chance I'm requesting.
There is a
because-
question. You can't just wait. This is 2018
She's
decree,
a widow.
25 now.
No, my lord is
And you
absolutely
keep
correct.
filing applications, don't bother. You file your application, that application also you don't bother, that is also dismissed for default. Then you wake up again after how many days? 1398 days after the decree.
My lord, absolutely correct, but only one chance may be given.
We find no grounds neither to interfere with the impugn judgment passed by the High Court, especially petition is dismissed.
Item number 18.
Please, minutes. This is a statutory.
Notice,
Grateful, my lords.
issue notice, returnable on 27th, 3rd November, service shall be effected by all modes and proceedings.
Just,
Delay kando.
there is a problem, especially with regard to the coal dust.
There's no delay in this. Next month. Yes, yes.
There's a problem out there, especially with regard to the coal dust, my lord.
Because there's a finding by the Environment Conservation Board also that this seems to be in violation of the environment laws. But
Absolutely,
that's been brushed aside by the.
absolutely, totally, my lords.
That will
And
have
as
to
far as
consider.
would your lordship also issue notice on this day?
Issue notice in the question, appeal as well as the prayer for, on the prayer for interim relief.
Item number 19.
May I please also.
Yes,
But in this matter, after 35 years, the High Court remanded back the matter to the respondent number 1.
but what is to happen?
My lord, what is-
Unfortunately, the High Court took so long.
My lord,
Your writ petition was of 1990.
please,
It is disposed of in 35 years later.
the thing is.
But the revisionary order is based on consent, and now it is found that there was no consent at all.
There is
So
an
it has to
issue.
be heard.
There is an issue. The High Court quoted the revision ground and the writ petitions submissions where it says that the appeal is filed without filing an objection. The case is.
The revisionary order is based on so-called consent. That is a fact.
So, if your lordship.
Now the High Court accepts your submission that there was no consent at all.
Lordship,
Once there was no consent, the revisionary order has to
High
be
Court
set aside.
consider my submission also, which says that the appeal
We
was
will only
filed.
direct the matter to be given
As far
priority.
as the legal issue is concerned, that the appeal cannot
They
file.
don't. However, we find no
Lordship,
ground in.
let this matter be, go back to
The
the High
interim
Court.
judgment passed by the High Court. High Court can't do anything. Now High Court can't step into the shoes of the
Lordship,
revisionary
that I
authority.
think the revision.
However, given the fact that the matter has been pending for decades together, we request the revisionary authority, don't say request, we direct the revisionary authority to give priority to this matter, which has now been remanded by the High Court,
So the legal issue is involved, your lordship.
and pass appropriate orders thereon on merits and in accordance with law as expeditiously as possible and preferably within 6 months.
Item number 20.
Please, minute. But even the defector complainant, sorry,
Yes,
the defector complainant, the PW2, we
we have
never.
already been exempted from surrendering, so we'll order notice.
Great,
Issue notice, returnable on
great.
17 November, so which shall be effected by all modes including this. Earlier order granting exemption from surrendering shall stand extended to the next date.
Item
Great.
1.
Yes, 21.
Malasya, I told 20, that's main issues pending, which is another.
No,
Malas,
that is a different issue.
Malas, no, Malas, then pass over,
It is a simple
no, Malas,
clubbing of FIRs within the state of Madhya Pradesh.
Malas, just kindly pass over,
High Court says no.
I'll pass over, I'll pass over kindly.
22.
Okay.
Yes, Lordship.
There also exemption was granted. But
Yes, Lordship.
was he in prison at all?
No, no, Lordship is not in
He's
prison.
not been in prison at
Yeah.
all.
Not at all, Lordship. So, Lordship, the
He's
allegation.
83 years old.
Yeah, he's 83 years old, Lordship.
Anyway,
Please kindly
issue
show.
notice returnable on 24th November. Service shall be affected by all modes including Dusty. Earlier order dated 11/7/2025 granting exemption from surrendering shall stand extended to the next day.
Deeply aware.
Wait. We have counters filed by respondents 1, 2 and 3. What about 4 and 5?
And 4, Your Lordship, I'm
You
appearing.
don't want to file?
We filed it, it's on
We
record.
don't have 4 and 5. Only 1, 2 and 3 are there. Only 1, 2 and 3.
In fact, one of them, which will become seminal, is Bunty Agarwal, who was actually the one put on trial.
4 is
Number
also.
5, he's not been served.
Oh, in 1, 4 is there in 23.1 alone, not in 23.
For Mahesh Agarwal, Your Lordship.
You filed only in one item, not in the first one.
Yes, in state of Jharkhand versus Radha Govind. That's where we.
You don't want to file in the first app. This is by the complainant perhaps.
We'll adopt it, Your Lordship, if need be, otherwise our entire stance.
No, your lookout.
Absolutely.
You don't want to file, you don't want to file.
Yes.
What I was indicating was,
Yes, Mr.
there are 4 of us who are not part of the original trial.
This will have to be heard though.
That's
It's a
right.
2022 matter.
I
Today, for some reason, the registry has dug up all the old matters, 2019 orders, 2022 orders.
In fact, this is a matter where, while it's a 22 matter, notice was issued to us only on 25th of January 25.
Yes.
And in that regard, what I'm pointing out is that this gentleman R5 has not been served.
R5 is not served.
That's what the office report indicates. And he will be relevant because he has now been acquitted of he was the only one who was undergoing the trial.
Insufficient address.
He's been acquitted. And I don't think that there is
We'll take it up on a non-miscellaneous day. You meanwhile complete service.
Yes, please.
We'll give you sufficient time so that person can be served and he can also complete his readings. Office report indicates that respondent number 5 is not served in both the matters or in one?
Both the matters.
Both matters. That remains unserved. Steps shall be taken to complete service. Effect service of notice upon him well before the next date of hearing to enable him to file his counter affidavit with him. List for hearing on 11th November. Reading shall be completed in the meanwhile. 11th November.
Could I request that the trial court record be called for because we were not parties there. So we have absolutely no ability to.
The trial court, perhaps the trial.
Application of the state was allowed by the trial court, my lord. Against that order, they went to the.
No, but the trial is ongoing, is it?
Yes, my lord. That's why they want to.
When trial is concluded, the gentleman will be acquitted.
Trial is concluded.
Yes, yes.
One of the appeal that's not.
R5 has been
One-
acquitted.
One.
He was the sole accused in the trial. He's been acquitted. So there is no
Now
trial.
the appeal is pending.
No
No appeal also.
appeal
No
filed.
appeal filed.
No appeal filed.
That's the issue.
If it's already over, then what will
That's
happen?
right.
Exactly.
My lord, they have come before the Honorable High Court against the order of CRPC section 319.
Very well.
That is the.
But the trial went on and one person has been acquitted, the others?
There was a sole accused.
Only R-
Only
R5, only
was
R5.
the sole accused. He was acquitted. Looking at this very material.
So
which
now
today-
are 2 to 4, whether they need to be subjected to trial or not. is the trial.
Of the self-same material which has been found to actually be unworthy of any credence by the learned trial court. And it becomes.
Can you show us the trial court judgment?
It's there in my counter.
Then it's absolutely.
Grateful.
I'm open.
I'm not giving it. Yesterday's order, it changed something in the third page. only. So we've already.
Respondent, my lords. I'm seeking some time for filing of wakalatnama and counter affidavit.
Your further respond.
Please, my lord. Sorry, Respondent.
Sole respond. Very good. Current counsel for the respondent seeks time to file his counter affidavit. Usual order. List on 3rd November. Earlier order of stay shall stand extended till the next date of hearing.
Letter was circulated in open forum.
Service is not complete. That also you'll have to take steps. Office report indicates that service is incomplete insofar as respondent number 2 is concerned. Then counsel for the petitioner, by way of a letter, seeks an adjournment on the ground of, on medical grounds. The matter is accordingly adjourned based on 27th October.
Item number 26.
Your Lordship, there's a delay of 474 days in filing the restoration application, my lords. The reasons have been given, my lords.
This is 2017, so we will give you a date.
You gave a date for final hearing, Your Lordship.
Hearing. We are not going to pick up this matter for hearing on a miscellaneous day. So you will have to wait till your matter is taken up on a non-miscellaneous day, or do you want leave to be granted? Then you have a better.
No, Your Lordship. No, Your Lordship may give me a non-miscellaneous day.
Matter being heard because 2 days would be available. If leave is not granted, then you will have only 1 day per week. So which one?
No, my lords, Your Lordship. Sorry, my lords. Your Lordship may give me a non-miscellaneous day.
List for hearing on 11th November.
This matter, parties have amicably settled it.
Only to some extent by the looks of it.
No, it's completely.
This implead application by the third party says that he purchased a part of the property.
That's right, that's right.
What about the rest of it?
Miller, my friend,
I am preparing for the petitioners. The settlement says that they have enacted for all the land and they've interchanged the land also.
But the agreement which is now filed, does it speak to that effect?
Look, they have shared the site plan also, and even I've got instructions from my client that they said that they've settled in terms of this very
Plan page 20, Miller.
No, show us that the entire dispute has been settled in terms of this compromise
No,
or compromise deed.
You will kindly allow me to refer to page para 11, page 18, Miller. Page 18 of this.
Page 18, para 11.
Yes. Second part of this para 11, Miller. Furthermore, parties do hereby also accept and acknowledge that the present compromise settlement will be produced before the Honorable Apex Court is the above said referred SLP number also, and SLP will be not allowed in terms of the present compromise settlement.
What about this is a settlement issue, consolidation issue.
No, it was sued for specific performance.
Specific performance.
Mine.
So the state is not involved.
No, state not.
So we'll close the matter in terms of challenge in this special
Application may be allowed, Miller, for implement.
For what reason? Any other way it's closing. You want the implead petition to be ordered?
Yes,
because they are
the
not
third
parties. So
Yes,
they need to be implemented.
Implead application. IA number.
It is
Implead application in IA number 166-289 of 2025 is ordered. And the implead applicants and the applicants therein are brought on record as respondent numbers.
So they'll have to file an amended member for that.
That is the difficulty. Yes.
So as per the applications there, respondent number, they would be proposed.
As respondent number 6 to, no, sorry, 9 are already there.
10 to 10 and 11.
2 of them are there.
Yes.
10 and 11. Sorry. Respondent numbers 10. No, there are more than
4 are there.
4, 10, 11, 12, and 13. Registry is directed to amend the cost title and include their names therein before issuing certified copy of this of the order being passed today. During the challenge in the special petition was to the order dated 22/5/2019 passed by the Punjab and Haryana High Court at Chandigarh in relation to a specific performance suit. However, during the pendency of this special petition, it appears that the parties have settled their interstate disputes and also brought in third parties. The third parties who have now been implemented as respondents 11 to 14. Full stop. A copy of the compromise of the settlement dated 11/7/2015 is placed on record. Para 18, para 11 thereof reads as under page 18. What's this paragraph?
Right plan be also good.
In the light of the aforestated development, the cause in this specially petition no longer survives for adjudication merits. The specially sections accordingly disposed of. Disposed of the terms and conditions of the compromise settlement shall be binding upon the parties and shall be scrupulously adhered to by them.
Great. If you like.
28.
Not the Arvind
This also the same issue. It's a 2019 order. So you want leave to be granted or you want a non-miscellaneous?
Council is in the personal difficulty.
Please listen to what we are saying. We will either give you a non-miscellaneous day, or if you want the option of 2 days, then we'll grant leave. Which one is it? Counsel for the petitioner.
Please, Mullahs, may I have it on a non-miscellaneous day, Mullahs? If it's
No, no.
convenient to your Lordship's board.
That if we grant leave, you will at least have 2 days in the week, which gives you a better chance of your matter being heard sooner. A non-miscellaneous day, it will be one single day, and you will go to the bottom of the list. You will not jump the queue because you're a 2019 matter. So once you join the queue, then you'll have to wait your turn.
Then, if your Lordships would be so kind enough to grant me leave, Mullahs, then.
Very. Leave granted. List as the matter pertains to the year 2019 and is ripe for hearing. Registry is directed to list the same on 29th October.
I'm so grateful, Mullahs. I'm so grateful.
Yes. 29.
Please, I beg to appear for the petitioner.
Yes.
There's a short issue which arises for your Lordship's consideration. The Lordship said issued notice, pleadings are complete.
This also perhaps requires a hearing. It's a 2019 matter. So same thing. Leave or NMD.
It's a 2021 matter.
2019 order though.
2009.
19 order.
Otherwise, the issue is very short. I can finish in 5 minutes.
Your option. SLP on a non-miscellaneous day or a civil appeal on a final hearing day.
I think my relative wants it on a non-miscellaneous.
Non-miscellaneous.
The issue is not very big. It can be disposed of for non-miscellaneous provided the matter reaches.
You'll have to wait your turn. List for hearing on 11th November.
Wait.
There was one number 1 in this matter.
Yeah.
In fact, what the High Court has done is actually pared it down to the
The
evidence.
enhancement of land acquisition.
I think my lords, why?
This again requires a hearing, Mr. Sharma.
That's all right. What if the Lordship?
So, do you want leave to be granted? That would perhaps be better.
I think so.
Yes. Leave granted.
But there's not. I hope your Lordships are not giving any interim order because I've got some 93 acres of land that I'm acquired. You know, it will affect everything. Your Lordship may simply grant leave. We can have it on whichever fixed date you
Well, leave granted as the matter is direct for hearing. Registry is direct to list the batch for hearing on 12th November.
File a written submission.
Written submissions not exceeding how many
3 pages?
3 pages.
In fact, 2 eyes.
3 pages. Very good. 3 pages shall be filed by the one counsel for the parties well before the next date of hearing. Read the file.
May I please, my lord?
Pass over in the matter.
Lordship, last order it was listed for an NMD day. Lordship, it will require some time to.
This appeal is still pending, is it? Before the
Yes, my lord, it is.
appeal is still pending.
Yes.
Now, applications are filed for substitution. Who all died? 2 persons seem to have.
Yes, my lord.
Who? To argue today?
My lord, we are being led by Mr. Senior Advocate, Mr. Gagan Gupta, which is why I am seeking a passover.
And your lordship, inadvertently, the rejoinder could not have been served on me. I
Why
took the copy today only.
Today only.
You had filed an application for impeachment. You had filed an
Yes.
application.
And then for deletion also, before they have, never like. Your lordship, that issue regarding rule.
We'll give you a non-miscellaneous
On rule 10, at the appellate stage, whether they can be impleted or not, that will have to be gone into your lordship.
They can be impeached.
Your lordship, there are some judgments where.
List
lordships have a-
for hearing on 14th of February.
Please, Lord.
This is
The
some
issue of
issue of interest.
Pendentality and future interest. 20.5%, Lord, by any stretch of imagination cannot be reasonable. Because for pendentality and future, Lord, section 34, it is within the domain of the court. At page 6, your lordship will have the calculation. Page 6 of the impugned order. Their total outstanding was 74 lakhs, Lord.
Come to page 7 though.
Yes.
That paragraph which deals with the interest issue.
Yes.
From the year 85 to 2000, no payment whatsoever was made by the appellant corporation. 2000, only 50% amount was deposited.
Yes. And then payments were made thereafter.
Therefore, it is evident that the respondent plaintiff has not been able to enjoy the fruits of the decree.
Both these parties were not public sector undertakings. The object of the
Don't you have
transaction.
this committee of ministers or something like that to resolve differences between PSUs?
In fact, Lord, my own.
That judgment of the Supreme Court is also there that why should PSUs come and take up our time? You need to resolve your differences interstates anyhow
That should have
from
been
the
done.
left pocket to the right pocket of the government.
Correct.
You're both PSUs. Why should you come before the court and waste our time?
My lord, they have. finally
That judgment, I don't remember the citation with regard to, there was a direction to the ministry to see that a committee of ministers is appointed to resolve these kind of differences between PSUs so they don't come before the courts and waste judicial time. Nobody is following that judgment, obviously.
Nothing.
At some point of time, there was a committee though.
Yes. One point.
There was a committee. Now you seem to have disbanded the committee. The judgment, Purana judgment hai bhul jao.
Case is also pretty old, Lord, but for a
Doesn't mean
principal sum of 32 lakhs, we have paid 3 crores, Lord, as
What
interest.
difference does it make? It's only your
Some
balance
amount,
sheets.
Lord, I am
Only for your balance sheets. Anyway, both of you are public sector undertakings.
And the business
Why
was
should
also
why should we waste our time on all this headaches?
20.5%, Lord.
You
Even
find out and let us know whether this committee is still there.
Very well. Very well.
We'll refer you to that committee if it's there.
Great, I'll do that.
The matter is adjourned to enable the land council for the parties to ascertain whether the committee of ministers, which was directed to be constituted by an earlier judgment of this court to resolve differences between state instrumentalities, is still operating, is still in existence, and is still continuing to operate. List on 22nd September.
Great.
Item 33, I'm appearing the second matter. My counter is ready.
Seeking a passover. Item.
Counter is ready, you need to file it.
Yeah, I'll file it today during the course of the day.
Seeking a passover 33.1, which is the connected SLP.
In which he will be filing a counter.
Reading says to be
Second matter.
One council appearing for which
Respondent
respondent?
number 4.
Respondent number 4 in SLPC number 843 of 2024 states that the counter affidavit is ready and would be filed during the course of the day.
Yes.
In second SLP,
Rejoinder thereto, if any, may be filed by the next date of hearing. Second SLP.
I have to file counter. First SLP and the petitioner, in other side and the respondent, there are 2 SLPs.
So the first SLP you need to file.
No.
Please get the numbers right. Are you asking for time in SLP
First matter, I filed my
843?
First matter, I filed my counter. The second
Number 843 is the one in which
Yes.
you need to file?
Yes.
And in which one do you need to file?
Rejoinder in second.
Rejoinder in 843. the petitioner on the ground that he had not filed an appeal before the appellate authority within time and therefore was not entitled to come before the High Court by way of a writ petition under Article 226 of the Constitution. Mr. Nataraj, ASG, appearing for the respondents, fairly states that the time consumed by the petitioner in pursuing other remedies can be deducted and the petitioner may be relegated to the appellate remedy even at this stage, and that the Union of India and the respondent authorities would not raise any objection on the ground of limitation if such an appeal is filed and taken up by the appellate authority. According to said statement, the writ petition is disposed of. Sorry, the specially petition is disposed of, leaving it open to the petitioner to file an appeal before the appellate authority within
4 weeks.
Why 4 weeks for that again?
But it's in a remote area for some lot. 3 weeks, not at least, because he has to come and sign. 3 weeks, not.
He has to file it in Tripura itself. He is there in Tripura, he'll file it in Tripura.
3 weeks, not 3 weeks.
Within 3 weeks. From
Not interim order, not otherwise. In the meanwhile, not because
the earlier interim order granted by this court on 4/3/2025 shall continue to operate till the consideration of the interim prayer made by the petitioner in the appeal by the appellate authority.
Not one more thing. All contentions are left open.
All issues are left open to be considered by the appellate authority.
Lordship was taking 3 weeks time.
Yeah. 47.
The Lordship, I agree with the respondents.
Concurrent remedies are dismissed.
Okay, for the respondents in the matter, we seek 4 weeks time to file a counter in the government.
Then Councillor
1 to 4.
1 to 4, it's time to file a counter affidavit. Equal in that regard shall be done within 3 weeks. Rejoinder thereto, if any, may be filed within 1 week thereafter. List on earlier interim order dated 9/7/2025 shall continue to operate till the next date of hearing. List on 27th October.
Grateful.
Great, please. It's coming after notice.
Perhaps has to be heard, Mr. Shankar.
Perhaps the small issue,
Very well, you wish to argue it,
legal
then
issue.
we'll take it.
The Lordships have time just to take a few minutes.
It's only 12 o'clock. We seem to have gone a little faster than anticipated.
Very. So let me just briefly tell your Lordships, I'm the bank.
Yes.
And there are essentially 6 title deeds that are deposited with me. Now, so a mortgage is created for 12 loans initially in 2008.
Yes.
About 4 years later, the same gentleman tells me that, look, there is one Raja Traders, which is separate. They have taken a loan. I'm standing guarantee. Please grant on the same terms.
He gives you a letter.
He gives me not only a guarantee agreement, which is entered into.
There's a separate agreement.
Separate agreement, which is at page 103. Separately, there are 2 letters of continuity. All 3 acknowledging the fact that this applies here. Now, I think the gentleman feels a little hard pressed with the fact that an OTS was entered into for the 12 loans, which were his personal ones.
Yes.
Once those loans were entered into, he expected all his title deeds to come back to him. 5 of them came back, except 1 which we withheld, saying that is towards the guarantee. Now he goes to the High Court saying, look, where is the question? They should have returned all of them. Our stand is no, that is still being held for that purpose. The impugned order, unfortunately, goes by the fact that it's a sizable amount, 67 lakhs. The impugned order goes by the fact that, look, you have to register. If your Lordship sees under the Registration Act, Section 17, and this is, I think, maybe an accident that happened because the same judges hear matters from Madras and from Tamil Nadu and from Pondicherry. In Tamil Nadu, there's a state amendment to the Registration Act, Section 17.
which provides that you must register deposit of title deed. But in Pondicherry, there is no such amendment. This is lands in Pondicherry. So I think the court may have misdirected themselves on that basis, because clearly in the counter affidavit here, it's the same ground they have taken. They've also, I think, been misled by the fact that in Pondicherry, you're governed by the law in Pondicherry.
Registration.
Give copies.
It should be carried out perhaps.
17, section 17. Section 17.
Pondicherry.
Yes.
And Tamil Nadu, is it?
Yes, there's an amendment specifically
Tamil Nadu.
reference to Tamil Nadu.
Instruments of agreement relating to
The H. No, the I.
Only F is there.
I.
We don't have.
F, G, H, I, the state amendment.
No, Tamil Nadu, only one single amendment is shown in this book.
Under 17?
Under 17.
Can your lordships have this copy? I'm surprised about that.
This universal perhaps doesn't carry out all the. Uttar Pradesh seems to have a longer amendment, but Tamil Nadu only one clause is shown.
Oh, I'm sorry. G, H, I.
Nadu.
Correct. So that's only for Tamil
Not
Nadu.
Pondicherry.
Yes, no, we should have copied this.
Towards first year. Seems to have taken a bath at some point of time.
That's true. Now,
this aspect have you considered?
Well, it's true, my lords.
The amendment is not there in
Amendment is
Pondicherry.
not there in Pondicherry.
Then where is the question of asking for it?
The other ground is there, my lords.
What is the other
They
ground?
cannot challenge that other ground. Plus, on two grounds. One is, my lords, with respect to 58F of the Transfer of Property Act. Plus, that, my lords, I'm not, my lords, opposing that. The other ground is, my lords, doctrine of estoppel and doctrine of lender's liability. Plus, the selective filing, my lords, they have done. But sorry, my lords, I may be permitted. This document, my lords, they intentionally not placed before this honorable court.
Copy to the other side.
Yes, my lords.
This document.
This is the, my lords, OTS settlement number 23 offer acceptance letter.
With regard to those 12 loans.
With regard to those 12 loans, my lords, lordship may kindly see DE, my lords, of the condition. Parties shall withdraw their claims or counterclaim or criminal case filed against the bank, its officials, if any.
This is in relation to your 12 loans. If you offer the same property as security for the other trader, whatever that means, Raja traders,
yes, my lord.
For that loan, if you offer a separate agreement or a letter of continuity,
yes, my lord.
Then apart from this, that charge would be there on that title deed, is it not?
That is their stand, my lords.
That is also there. You entered into an agreement. I wasn't in fact aware of that agreement. Page 103.
It is there.
I thought there was only a letter of continuity.
Yes, well, we find it as an additional document. That's why it must be.
You entered into a separate document also.
My lords, but my lords, my lords, lordship may kindly for a moment pay E also, condition E. Charge on security or title deeds shall be released to the rightful owner of the property.
That is in relation to your 12 loans.
Yes.
This can't extend to your other extended guarantee which you gave for Raja traders.
We released 5 loans. Pursuant to that, we released 5. One is left.
One is left.
The total outstanding amount was, let's 2 crore 57 lakhs. We settled it, my lords, for 1 crore 79
Please
lakhs.
understand that your OTS is separate. Your 12 loans are separate.
Yes, my lord.
That is over.
Yes, my
You got back your 5 title deeds.
Yeah, other title deeds.
In the light of this extension that you gave, this letter of continuity and this other agreement of guarantee which you gave
Still they are
for that Raja traders, they're entitled to hold this property.
But they did not disclose anything, my lord.
Where was the question of disclosing? You gave a guarantee.
My lord, that is, my lord, their claims.
Did you not say that this property is to be held in this document?
Page 28, my lords. 27/9/2013, page 28. That is letter of condition.
Same date is 103. Guaranteed.
In this agreement, this
Yes.
guarantee agreement.
Page 103, second para. middle of the page.
Second paragraph.
Whereas at the request of the guarantors, the bank has agreed to allow, continue, enhance an accommodation by way of term loan account favoring Raja traders, hereinafter called borrower, on the terms and conditions contained in agreements dated so and so, has agreed to guarantee due payment of the amount due to the bank. This is the same person, Siva Subramaniam, who is respondent number 1. At the top of the page, that's agreement is with Siva.
But where does it refer to this document, which you are now retaining?
The title date, no?
Yes. In the letter of continuity or in the agreement, does it say?
Letter of continuity, yes. Letter of continuity says so. 28 and 30. Two letters of continuity.
8 and
30. So, if your lordship sees page 28 beginning, I have already on so and so deposited with you. It says limit sanction to Messrs. Raja Traders at the top. 28 first line. Read with page 29.
So this is the document that you are holding on.
Yes, yes. Page 29.
The other documents you returned were also pertaining to property at Pondicherry or Tamil Nadu?
Pondicherry.
That is also.
Pondicherry. So at 29,
yes,
he says, I confirm having already agreed with you on 27/9/13 that the title deeds of the court shall continue to be held as additional security.
Now, page 33 for a moment, my lords. Page 33. Plus, what by learned senior referred is not to unregistered letters. Page 33 is the registered memorandum of deposit of title deeds, which is dated 24/11/2015, my lords. Well after these unregistered documents. Now, lordship may kindly see, my lords, page 34. It's a bilateral agreement, my lords. Even bank manager is also present, my lords, and he signed the deed. Now, my lords, the relevant portion, page 35, my lords. Page 35.
Yes.
Second paragraph. The mortgagor declares that the documents mentioned in the schedule which deposited with the bank are the only documents of title mortgage relating to the Schedule 2 property, and there are no other documents of title or so. The mortgagor further declares that the scheduled property is not charged or encumbered in any way whatsoever. Then the other paragraph. There are no claims.
How does this help you?
Well, this is the registered document, my lords. What my learned senior says is earlier unregistered letters have been given. Once, my lords, they have registered the mortgage deed, then, my lords,
This
they
is
cannot.
in relation to which loan though?
My lords, that is also referred, which is at page 33.
This is one of your 12 loans, perhaps.
Yes, my lord. This is the registered document.
No, but in relation to your 12 loans,
My lords,
there are two separate things here.
they did
Your
not
12
include
loans,
those loans.
that's separate,
Yes, my lord.
and your guarantee for Raja Traders is separate.
Yes, my lords. Here I am the borrower, there I am
So
the
you can't try to merge both of them and say that in relation to my OTS and my 12 loans, you did something. So therefore, I should get the benefit for Raja Traders also.
No, my lord.
That can't be.
My submission is very
That is
limited.
exactly what you are asking for.
My lords, these, my lords, they did not include those loans also. And they are, my lord, also endorsed with that there are no other security over this property.
There's no necessity for registration in Pondicherry.
But once they, my lords, committed to register the document, my lords,
If they did
cannot-
it, which is not required, there ends the matter.
Lords, what has happened is, my lords, in Tamil Nadu, amendment came into force, my lords. Immediately, my lords, they insisted us to register all the MODs. So we registered the
In
MODs.
the High Court judgment, where does it say that because of this factor?
Page 3, my lords. Page 7, first 3 lines.
First 3 lines.
Mortgage cannot
Without
be extended
register.
by any other loan that is not secured by a proper instrument without a registered document.
Lords, I was, my lords, under legitimate inspection, my lords, expectation that my properties will be released. Both are.
You gave a guarantee in your own wisdom. You gave a letter of continuity.
Most 25 cities.
Are you not in management of the Raja Traders also?
We don't know, my lords. No,
Why did you give a guarantee then?
But he is
Out of
my
the
relative.
goodness of your heart, you gave it, then
Relative.
suffer for it.
Relative. You see, relative, my lords,
No,
because
I
they are also, my lords, having a loan, my lords, and having collateral security properties. That's only one submission, my lords. They did not make any disclosure. My lords, 15 to 20 sittings were
You
happened.
gave a document. Once you executed.
These are afterthought, my lords. After receiving a huge amount of 1,79 lakhs.
Your wisdom is an afterthought. In hindsight, you realize maybe that you ought not to have done it. What is the
But if they would have informed me earlier, my lords, I would have
informed you earlier about what?
Lords, I'm not at all aware about the 2013 letter of continuity. It is true, my lords.
What do you mean you're not aware? You signed it.
Only, my lords, before High Court, my lords, they introduced. After
Did you
reject,
not sign it? It bears your
that is
signature.
submitted, signature is submitted.
Then what do you mean? I
I
don't
can
know about.
understand the heartburn of the client, knowing banks, my bank should have been more transparent, I agree with that. We should have said that, look, there are 13, I'm warning you, this 12 is.
They did not disclose anything.
But that's not a lack of disclosure. Both parties knew what was happening.
You signed this letter.
That's admittedly, but that's
Sorry, Counsel.
they had also suppressed many facts.
Been granted. Challenge in this appeal is to the order dated 24/7/2024, passed by a division bench of the Madras High Court, holding that the action of the Punjab National Bank, the appellant herein, in retaining the title deed of the respondent, the petitioner before the High Court, in relation to a particular property which was offered as security for the loans availed by a third party, Messrs. Raja Traders, from the appellant bank, has to be returned to him. Perusal of the impugned order reflects that the division bench was of the opinion that the deposit of title deeds by the respondent in relation to the aforestated loan transaction of Messrs. Raja Traders could not have been effected without a proper instrument, proper registered document. In this context, we are informed that an amendment was made in section 17. A state amendment was made in section 17 of the Registration Act 1908, only insofar as the state of Tamil Nadu is concerned, which require
Which inserted in 17.
Clause 17 within brackets I, 1 within brackets I. Whereby instruments evidencing an agreement relating to the deposit of title deeds were made compulsorily registrable. However, no such amendment finds mention insofar as the state of Pondicherry is concerned, and in its applicability in the said state, Union Territory of Puducherry, now Puducherry is. And insofar as the said Union Territory is concerned, the amendment made in the state of Tamil Nadu would not have application. The understanding of the division bench, which is obviously based on the Tamil Nadu state amendment, is therefore erroneous.
There are 3 judgments of this court also.
Perusal of the material based on record indicates that the respondent executed letter of continuity dated 27/9/2013, whereby he stood as a guarantor for the loan advanced by the appellant bank to Messrs. Raja Traders.
So there are 2 letters, 27/9/13 and next page, 6th May 15.
Executed letters of continuity dated 27/9/2013 and 6/5/2015, whereby he stood as a guarantor for the loan extended by the appellant bank to Messrs. Raja Traders, and categorically stated that the title deeds of the immovable property deposited by him with regard to the property situated at Pondicherry, as detailed in the said letters, could be retained as security for repayment of the said loans. Apart from the same, he also entered into an agreement of guarantee on 27/9/2013, stating to the same effect. In the light of these documents, the respondent cannot seek to disown the liability attaching to him in relation to the repayment of the loan by Messrs. Raja Traders, as he stands as a guarantor for the same and offered his property as security therefore. The action of the bank in retaining the title deeds. Only one title deed deposited by the respondent in relation to his property at Pondicherry as security for such repayment cannot be found falsified. The impugned order passed by the Madras High Court is accordingly set aside. The appeal is allowed in the aforestated terms.
That's only one indulgence. Raja Traders also has submitted OT's proposal. They kept it pending. Let them expedite that so that I'll get my document. Some observation.
It is for the bank or second. Some OTS is under consideration.
Just checking. They have submitted it, but the time has lapsed.
Oh, it's not also. Yeah, so we won't say anything. You repay the loan and get your document.
Even after payment, obliged. Wait for me.
He said, I am not tainted. The high
tainted candidates on the face of it.
No, I am not in the 3 list.
You were not continued after the 17th order. That is recorded by the High Court.
No, but the point is not only 3 classes are tainted.
The very fact that you were not continued shows that you are the tainted amongst the tainted candidates.
No, I was
none of the petitioners before this.
I have been given an admit card, I was given an admit
wrongly given. That needs to be
required. But somebody.
We've in fact said that even if they don't find out, if somebody brings it to their knowledge,
no problem. But somebody should examine my case. The High Court says Supreme Court will examine.
You've already been stopped from teaching.
That is true.
By that, you got the signal that you were amongst the tainted candidates.
No, with great respect.
And recovery also has been initiated against them.
No,
that is still
that is not so. Your lordships cancelled.
We've heard several matters.
Your lordships,
you are one in a long queue.
I know, but in one case, your lordships asked him to go back to the High Court to explain.
No, that is a person who filed a writ petition before the division bench judgment. She had filed a writ petition before the division bench judgment saying that
but we have not been terminated as yet.
The tainted list is.
But we have not been terminated as yet.
The High Court has recorded it in clear terms. None of the petitioners before this court are presently working as assistant teacher.
We are not terminated.
To the 17th April order.
We have not been terminated. That's what I'm trying to say.
You are tainted candidates. There is nothing we can do.
I am not in those 3 classes. I am not terminated.
You can't.
Somebody should examine my case.
Sorry. You find no good ground and reason to interfere with the ensuing judgment passed by the High Court, especially petitions according to this.
Item number 51.
This lot will be deleted. It's only taken up in the
examination had gone very peacefully. And 14th we are waiting.
No, but these people, are they tainted or are they
tainted?
Why is it that you don't have clarity on that issue?
No, tainted.
The CBI came up with a list of tainted candidates.
We have given them in
on the website.
We have given them in the
clarity on that.
3,000 teachers were appointed after expiry. In contempt of your loss they have been allowed and they have been allowed.
These are all from the bar.
There's no
The
point.
problem is I can't match with the statements made from the bar in Supreme Court. If it is a pleading, I can match.
There is a specific treaty.
After the event, we will examine whatever needs to be examined.
3,000 teachers they have applied.
51 matters coming up because we said not to be deleted, but otherwise this requires a hearing.
The Lordship in fact said so.
Some interference.
Request, brother. The Lordship
have in fact directed it to be listed on an NMD.
On a non-miscellaneous.
Milord, there's one action which we need. Milord, looking at the calamity which we are suffering in the state of Himachal right now. Milord, may kindly have one thing. Milord, from last 2 years, the department is writing letters to the Supreme Court. It is there on record. Milord, in the last letter, Milord, 321 posts are beginning.
It may be better if we grant leave so that you will have a higher opportunity of getting
Milord,
back.
kindly allow me to at least fill the post of begin post.
Without you create the mess by not having proper rules for inter se seniority integration.
Exactly, ma'am.
Then you create the mess and then you say that I have vacancy.
1978 note P specifically mentioned that the seniority should be considered as per the length of services, my lord. Even otherwise, my lord, they have the
Mr.
given
Patwalia, you are appearing for
the petitioner. It's a common selection. They are lower in merit. In some areas,
My lord, it may be kept for hearing. This has to be heard, my lords. All the promotions are being made. They are.
How many vacancies are there? You are for the state.
Yes, my lord, I am appealing for the state. Not what was known to me was 321 out of 801 posts in the cadre. Out of 801, 321 was vacant.
Both posts are equivalent, is it? Deputy
So
forest.
they are also insisting that they will not promote.
No, they are not equivalent. I'm sorry.
Now
I'm intervening, Lordship.
Problem.
They should promote the direction of the court. Did the court direct me that I can fill the post?
Lord, what your lordship may do? Your lordship may list it.
Create further.
Yes, your lordship may list it after 2-3 weeks, 4 weeks. We'll
Let the
argue
court
it.
direct.
It'll take 15, half an hour.
Leave granted.
The learned
As
AG
the
is on
matters are
there.
ripe for-
Learned AG is there, not online.
As the matters are ripe for hearing, we'll give you a date, Wednesday's date, so that you can argue the matter. List on 8th October.
All right, great.
My lord, only one thing is there, though it is coming early. My lord, it is that the posts are lying vacant, and in forest we have a 68% land as a forest land, and we need forest deputy rangers.
But this can't just go on, this perpetuation of heartburn because of seniority issues.
My lord, no seniority will not be disturbed. We will promote them in accordance with present setup.
No.
All will be promoted. Seniority will be framed after my lords will direct.
The present setup is valid setup or not?
Let it.
That will 8th October will decide.
Please, your lordship. Please.
Hopefully, if it reaches on that day, 8th or 9th.
May it be listed on the top of the board.
No. If 8th it doesn't reach, it gets carried over to 9th. So those matters will be taken up before the 9th list. So either way, you stand a better chance of your matter being heard once we take it up on a Wednesday.
I agree.
11.
I am for the state.
You're for the state.
Yes, look, the sealing proceedings have been watched entirely.
This bar of the civil court jurisdiction, we don't have that provision before us. Section 11(2) at least has been extracted.
Yes, the entire proceedings have been put on notice, was not trial court found in my favor.
According to the High Court, you've not followed the procedure. If you don't follow the procedure, then the High Court is justified in setting it aside. No hearing, no inquiry. The bar of the civil court jurisdiction, we don't know how it reads the provision.
Look, may I just say this?
If you don't follow the procedure at all, then is the civil court's jurisdiction still barred?
Look, the sale deed was also not produced before the trial court.
Nullity. Then it goes. How do you get over the finding of the High Court that you did not follow the procedure? 11(2) procedures. Page 4.
Look, they kindly have the finding.
Now liberty is given perhaps to you to give an opportunity of hearing and then pass a fresh order. Why don't you do that?
First appellate court.
Why don't you do that instead of wasting time here?
Let me very well say that then, because in the order of the second appeal.
On the face of it, once you do not follow the 11(2) procedure, why should we interfere then? You obviously did not have an inquiry where you gave them an opportunity of hearing.
He was a subsequent. He was subsequent.
Not on merits. You need to follow the procedure. Did you follow the procedure? Yes or no? Did you hold an inquiry? Did you give an opportunity of hearing?
Evidence was led. There was a mutation entry that was produced before the trial court. In that mutation entry, it was also written that sealing proceedings have been initiated. Well, we kindly have
restrictions on transfer The procedure is section 5(1) is the restriction.
Yes, Lord.
Inquiry has to be in terms of rule 7 of the rules of
Yes, Lord. Notice has to be
1973.
given to the transferee.
That you have not done.
We kindly have the finding of the trial court from on page 24, my lord. Para 10, my lord.
Para 10.
Well, the analysis of the aforesaid evidence.
Yes.
The analysis of the aforesaid evidence is in the manner that Kailash Chand has stated during his court statement that he had purchased the disputed land from Umrao Singh according to Exhibit P01. Umrao Singh had purchased this land from Godavari Bai. I do not have knowledge if any sealing case would have instituted against Godavari Bai or not. In connection with the Khatoni Khasra number, when notice came, only then came to know about the sealing case in respect to the disputed land.
So who, according to you, was heard by you before you
Well, we kindly have 2 more lines. Whereas Leeladhar, DW1, has stated that the disputed land was purchased by the plaintiff from Godavari Bai, and in respect of the said land, declaration of being the surplus land was made. After declaring the said land as surplus, notice was also issued. The entry of surplus land of 43 acres and 14 decimal is marked in Exhibit D1. This fact is also...
There is no mention of the procedure being followed. There is no mention of that, of an inquiry, of an opportunity of hearing either to Godavari Bai or to the other person, Umrao.
The land...
Nobody was heard.
She purchased in 1986.
We find no good ground and reason.
My
Later known, we find no good ground and reason to interfere with the interim judgment passed by the High Court. The petition is accordingly dismissed, reiterating the liberty given by the High Court. Where did this be so?
The liberty was granted by the first appellate court.
By the first appellate, granted by the, reiterating the liberty granted by the first appellate.
Like,
especially petitions according.
Malak, this is for consolidation of the FIR. 6 FIR has been written.
Yes.
21 Malak. Malak, this is for consolidation of the FIR. Malak, 6 FIRs has been registered in the state of MP. Malak, for a moment,
each complainant is different. Each complainant has a different set of facts. There is a question of consolidating.
The facts of the all complaints are same.
Right. Each of them has been taken for a ride individually. They're not all joined together and giving money.
For a minute, only just can consider. First of all, so in out of 6 FIR, only in 1 FIR charge sheet has been filed. In other FIR, even the investigation has not been completed yet. In the after passing the 4 and 6 5 manner. Just can you see the page number 180 format only?
We are only on the ground whether this is a fit case for consolidation of
FIR. Just can you see the page number?
If you do each complainant individually, each of them has a different story to tell.
It was a common story at all.
There's how will it be a common story? Commonality would be that you've taken them for a ride.
Just kindly see
that is only commonality. Each of them will have a different set of facts with regard to how much money they invested, who got them to invest, who induced them to invest, how they were persuaded to invest.
Just kindly consider just kindly consider page 2 pages only. Just page number 180. Then 180 page number. This is an order of this honorable court on 18 January 2023.
This is a different.
Not different. This is the same case. This is the same case by court arising from the bank food. And just can you see another page?
118. We know about this order. You are aware that we are dealing with such in your brother's case before us.
I understand, just can you see? Page number 200 for a minute, This honorable court has granted liberty. Then I filed a writ petition before the honorable High Court. Just can you page number 200 for a minute only.
Know that liberty.
Page number 200. Just kindly, may I read the having regard to the counsel for the applicant, we are of the opinion that the applicant must have moved the judicial High Court by filing the application under section.
Now that you filed it and the High Court has considered it.
Just another thing, in the same type of issue, the Honorable High Court has on a different footing. Just can you see the Annexure P11, relevant para page number 197, 195, start from the page number 19, para 15. So similar footing, different opinion has been taken by the Honorable High Court. Just can 195, page number 97. 195, para 15, my lord, sorry. May I read para 15, my lord, for a minute, my lord? The same FIR, same cause of action, same things, my lord, has been consolidated by the Honorable High Court in a single matter, my lord. Para 15. Arising from the same dispute, my lord. Same type of dispute, my lord. May I read?
Is it the same learned judge though?
Not the judge is different, my lord.
But the
We
same
find the reasoning offered by the learned judge in this order to be
Malad, just
completely.
kindly consider. Malad, just kindly consider the same thing has been Malad for a minute. Malad.
The
Process
is not there
out of
to facilitate
It's not Malad, the petitioner is
of the accused.
Malad, just kindly consider out of the 6 FIRs, investigation has not completed then Malad, investigation has not completed yet in any FIR, Malad.
The specially petition is accordingly dismissed. We must, however, compliment you on the speed at which you are able to speak though.
I'm so sorry, Malad.
No, we are complimenting you. It is truly incredible that without even pausing to take a breath, you can go long distance. You're a singer. You also sing.
No, Malad.
No, you should go into singing also then. Amazing capacity you have. Yes, but in a better case though.
Much obliged, Malad. I'm grateful.
34.
I praised my IA 209843 that they should maintain the status quo over the lands. They should not acquire the land, when this proceedings is pending before this.
Now the High Court holds that the notifications lapsed by extending section 24 to it.
Yeah, 24, my lord, even 11A is not applicable. This court has already held so. That kind of
But under the 1965 enactment,
yes.
Are there any time stipulations or are you entitled to go keep the matter pending for decades together?
That is what has happened is the petitioner, the respondent files a writ petition before the High Court in 2015, got a stay order as a result.
Have you filed a full copy of that 1965 Act before us?
No, my lord, I can file it.
We'll have to see the provisions.
Yes, yes, my lord.
It's not possible that you are at liberty to just sleep over a process for decades together and say that I'll fall back on my 2009. What is that?
The problem was by an interim, the High Court stayed.
2009 notification.
In his case, the High Court stayed. Then he says after 6 years, he withdraws the writ petition, stay is vacated. Then after 1 year, he goes to the court saying, please give me compensation. The first prayer, look at 108.
No, but in the meanwhile, while we are seized of the matter, what are you doing now?
Lord, we can't take possession because you are.
He says that you're trying to take possession.
My lord, that's wrong.
We'll record your statement.
But I must say, tell you.
Shall we record your statement?
Yes, you can, my lord. I have made the award but not published. But what can be done? Look at this is 543 acres.
For a housing scheme.
Housing scheme. Somebody goes and the High Court was the entire notification. I can understand to that extent. How can the High Court pause the entire notification? I want, my lord, so far the petitioner is the respondent.
Let us see that act also. Please have the.
I will have the act, my lord. I can give the lordship.
We will give you a date and we'll record the statement of the lord.
What is happening? Just 2 minutes. So far, their respondent are concerned. Your lordship may say status quo. Other poor fellow, they are entitled to compensation. Till now, they have not compensation. And
no, but unless we set aside this,
yes, that's right. But your lordship can give a liberty. But then now the judgment has come from this court. If there's a delayed accusation, forget about the old act. Give the compensation under the 24 Act. Justice Surjakant judgment.
No, that is perhaps the 1894 Act.
Yes, this is under the 1894.
No, this is under your 1965 Act.
1965 Act. Yes.
So it's not under the 1894.
That's right. But that has made applicable to us.
Which one?
The
1965 Act says 1894 would apply.
No.
Then
they have, by virtue of a judgment of this court, they have said, so far compensation is concerned, don't deprive them. If there is an amendment in the Land Acquisition Act, whatever, please pay them because...
In the context of your 65 Act, this judgment...
Yes, they have said so.
So that is only for computation of...
For the computation of compensation. The reason they have given is, look at the same...
That extension will not mean that 24 would apply or...
Yeah, that's right. That will not apply. Compensation, yes,
if the judgment you show us.
And so that, my lord, judgment, if your lordship so want.
May just find out, my lord, what is the question of law involved in 1 minute? There are 3 acts: Land Acquisition Act of 1894, then there is Adhiniyam, my lord, of 1965, and then there is a Land Acquisition Act of 2013. What this act, section 55 of UP Awas Vikas Adhiniyam 1965 said that land acquisition will be taken place as per the Land Acquisition Act 1894. They have incorporated that provision. Meanwhile, my lord,
We don't have any of those provisions. So
that's what I'm just stating in brief. Now, my lord, meanwhile, what happened? That act has been repealed. Now, what they are saying?
Which act was repealed? 1894 Act.
30 Act has come in place. Now, they are saying that we will not be governed even for paying the compensation for, as per the 2013 Act, we will be governed by 1894 Act, because we did not make any changes in 1965 Act. My lord, all the judgments I have read, my lord, from the Land Acquisition Act.
That is with regard to the computation.
Yes.
We are now on the first issue, whether your notification is clear or not.
Our contention has been rejected by this court so far compensation is concerned. I don't know why he is repeating that. That's the judgment of this court.
Because
I don't know.
No, only see, my lord, this.
Now,
LAC
then senior counsel is saying that the 2013 Act would apply.
No problem
with judgment.
So far as computation is concerned, 2013 Act.
What we do, my lord, is not final. It is subject to the order of this court. This court is.
Now, do you want leave to be granted? So
No,
that
my
we
lord,
can
don't
take it up
grant,
on-
the others will be affected. Those who are not.
No, if we grant leave, it stands a better chance of being heard sooner.
No, but the only.
Otherwise, non-miscellaneous day, one Tuesday per week.
If your lordship
You
says,
join the queue.
if your lordship says status quo with regard to that land, their
No,
land.
there's no point.
Okay, it's all right. It's all right.
Notifications are gone
I leave it to your
in
lord.
terms of this judgment.
Because otherwise, my lord, what happened?
When we'll grant leave so that
Tell your lordship what is happening.
give you a
Your
specific
your
list.
lordship have wide experience. What is happening is those who have not come, the builders are instigating. As a result, everybody is going to the writ court, high court. We are in difficulty. That's the area where
give you a leave
concern.
granted as these matters are ripe for hearing and required to be heard expeditiously. Registry is directed to list this batch of cases for hearing on 19th November. 19th November.
Lord, by that time, if the status quo can be provided, I'll tell my why.
We take on record the statement made by the learned senior counsel appearing for the Uttar Pradesh Avas Evam Vikas Parishad that no steps are being taken to
Take possession.
take possession of the lands in question.
Correct, my lord. But your lordship fix a date.
We've given you a date, 19 November. 40.
This is coming after notice, my lords. I don't think I should bother your lordship.
40.
Lords, yes. My apologies for my absence on the first call.
Observation. Now the suit is gone in.
Yes, sir. It was for a limited purpose. And as per my instructions, it was
Mr.
never
Deshmukh,
inducted there.
Suit's gone.
I have a miss.
Let him answer. You're not letting him answer.
I'm sorry.
No, the liberty, my lords, the Honorable High Court has granted me liberty. So as and when, my lords, even if I go for a suit, that is the prerequisite for it is a Section 18 notice. The lordship also recently ruled on that. So if that still remains, not shall take
No,
my
but you filed a suit and it's dismissed is what we are told now.
No. Plaint is written, that is recorded in the first impugned order as well, in paragraph 8. But that was.
After that, you've not taken
After that, no steps are taken. So if I issue notice under Section 18, my lords, again a suit is still maintainable. The lords is already held. That's why, my lords, I said that though this is coming after notice, I should not bother a lordship.
So you don't want to press the man.
Lords, the liberty is already there, my lords. It is there in the first.
So do you wish to withdraw it or you want us to close it?
Your lordship may close it, my lords.
Which page is this observation?
Your lordship should get that, my lords, in paragraph number 6.
Those are only observations. You know.
Paragraph number?
Paragraph 4, my lords, page 2.
Yes.
I'm sorry. The my lords, last but fifth line. He fairly admits that the plaint in the civil suit filed by the challenging order
Which page are you?
is written.
Paragraph number 4.
Paragraph number 4 at page 2.
Yes. He, however, fairly admits that the plaint complying has some provisions and filed the present request. Where is the liberty there? There's no liberty as.
No, there's no liberty. That's it. There's no liberty. Only the
On it
observation.
also, I have a very good case, but I will not say anything on that.
In the light of the statement recorded by the High Court in paragraph number 4 of the informed order dated 7/10/2022, Mr. Deshmukh, Senior Counsel, appearing for you. You are a designated, not yet, learned counsel appearing for the petitioners. States that the petitioners would be taking necessary steps to file a civil suit in accordance with due procedure. In the event, we'll say that the observations shall not be.
Yes, my lord, it will not come in my way. Otherwise, since last 2 years, this matter is
the
pending.
petitioners file any such suit, the observations made by the High Court in the informed order and the dismissal of the special petition shall not influence the trial court, which shall consider the matter before it on its own merits and in accordance with that. Subject to the observation, especially petition is dismissed.
My lord, and so highly obliged.
That's all. Then all the orders. You have my, otherwise ask for the proposal email. So you still have.